Our final session has been sponsored fittingly by UC Berkeley's Institute for Global Change Biology. We really appreciate their support. Our moderator today is Lester Snow, who's Executive Director of the California Water Foundation. He previously was Secretary of the Resources Agency, Director of the Department of Resources, Executive Director of the CalFed program, among many other positions involving management of our water resources. Thank you, Lester.
Thank you, Mike. That last panel, I learned a great deal from it, but I thought there was a state law that prohibited 5 or more attorneys from being on one panel. And if not, Tina was here earlier. Can we have a bill early in the session on that point? The last time in all these previous jobs that I've ran away from in the past, surrounded by this many attorneys, it never has gone well for me. So we'll see how today goes. I like the way that this program has been set up, and you certainly have heard kind of the history of 20 years ago and how we got here with public trust, and then a discussion of, I'll call it current conditions, and even the last panel got into a little bit of where do we go from here. I mean, that was an implication of a number of the exchanges. And this panel is really, in my opinion, where do we go from here? And the way I look at it, especially when I look around this group, there's a lot of, I'll call it parents of the public trust doctrine as represented in Mono Lake, a lot of people that are responsible for making that happen. So I was kind of thinking of Mono Lake public trust as a 20-year-old child that we brought into this world. And as a 20-year-old, they're thinking about, where do we go from here? What am I going to do? Am I going to stay in the little valley, or do I go to the big city? Do I keep focusing on surface water, or is there a whole bunch of other things that I need to focus on? So we need to take care of our child, and that's what this panel is going to do. So I just kind of threw them a loop here in terms of their presentations. But think of it as we have this lovely child, and she's wondering where she goes from here as public trust doctor for the state of California. So we've got a great panel, and the plan moving forward here is go in order that they are on the agenda. I'm going to introduce them. We're going to do presentations, and the panelists will respond to each of the questions that they've been assigned, and I'll read those questions just before each one gets up here. But let me start by the extremely brief introductions. The guidance we were given as moderators is say their name and that they're still alive and move on. And I'm not going to deviate much from that. Michael Loffer is going to be first up, and Michael is the Chief Counsel for the California State Water Resources Control Board and the 9 regional boards, and he's been in that position since 2005. Michael began his legal career practicing environmental law with a large firm in San Diego and San Francisco, and so he probably has either sued or defended everybody in this room at some point. After Michael is Richard Roos Collins. Richard is principal of the Water and Power Law Group in Berkeley and Cal Trout's attorney on all of the Mono Lake cases. And I suspect while Nancy was complaining about all the cases that Cal Trout files, Richard probably filed 4 or 5 more while he was in the audience. I don't know if Nancy's still here or not. Then third will be Tim Quinn. Tim is Executive Director of the Association of California Water Agencies. He's held that position since 2007. Previously Deputy General Manager of Metropolitan Water District. And something that I did not realize, Tim appeared twice as an expert witness in economics and water management in the Mono Lake cases. And maybe we'll hear a little more about that. Fourth on the panel is Matt Condolf. Is a geofluvial morphologist, and I'm proud that I was able to say that the first time through, an environmental planner specializing in environmental river management and restoration. And lest we forget, all public trust issues either do or at least should emanate from knowledge and science. We forget that. They don't emanate from the legal principles. They emanate from knowledge. Right, Matt? Okay. Thanks for the 20 bucks for me to say that. And then finally, and I can't think of anybody more appropriate to talk about this issue than Martha Davis. Martha is Executive Manager for Policy Development at the Inland Empire Utility Agency. And I think on this occasion there's only one way to think of her, and that is in her role as Executive Director of the Mono Lake Committee, 84 to 96. And I talked about the parents of the Mono Lake decision, and there could be nobody more aligned with that than Martha. And obviously she did that when she was 10 years old, and that's very impressive, I might add. So let's start. And we will start with, as I mentioned, Michael Loffer. And his question was, can the adjudication procedure that have functioned in a simple case like Mono Lake, relatively clear issues and limited number of parties, translate to larger and more complex basins such as the San Joaquin? Michael?
Thank you very much, Lester. And I think it's safe to say that since becoming Chief Counsel for the State Water Board, I have just been sued by everybody in this room, or at least my client has. We've set this panel up in a fairly structured way, and we're going to have very brief presentations from each of us. And my job here is to essentially perhaps throw a little bit of cold water on how good this child from the Mono Lake decisions really is, and whether or not the parenting skills we earned here, maybe dragged kicking and screaming by Justice Police at times, can extend themselves out to more difficult children around the state. And I apologize for how strained that is, but Lester really did give us no notice that he was going to use a child analogy. Almost everyone in the room is an attorney. That's unfortunate for Lester, but it's also going to be an opportunity just to go back to law school briefly, because I want you all to think a little bit about how the Water Board does decisions and how extensible some of its decision-making processes are to the very complicated issues we have before us. And when we look at decisions, and I as attorney for the board, we often start off by looking at them in the lens of, is this an adjudicative decision where the board is acting in a court-like fashion, or is it more of a legislative decision where the court is stepping in and making broad policy determinations from legislative facts? And it should be pretty clear from hearing Board Member Del Piero's presentation this morning, and for anyone who's actually read the decision, that the board was looking through the adjudicative lens when it was asked to decide the Mono Lake decision. And that has some fairly significant limitations that I want to work through. But when I tell you all to go back to law school, I want you to think about some of the things that are hallmarks of adjudicative decisions. They truly tend to be focused, single-party type issues. When you put them into, take an adjudicative decision in court, you're used to seeing rigorous rules of evidence, prohibitions on ex parte communications with the judges, very defined rules on who is an expert, submission of testimony, how we get to a decision. And that's equally true when the board is carrying out its adjudicative functions. It really is a straitjacketed proceeding where you're going to have very well-defined parties before you. The witnesses are going to be pre-declared. They're going to be subject to cross-examination, redirect, recross. It really does look like a court proceeding. And in this respect, the Mono Lake decision really was the ideal case to bring a public trust adjudicative proceeding before the board. You really were fairly focused, and it lent itself to that type of decision-making framework. You had one water right holder. The panel before us was a great panel, and one of the things that they discussed was the fact that, how does the public trust doctrine apply to the myriad water rights we have in California? Well, the nice thing about the Mono Lake decision, there was really only one species of water rights that was at issue in the decision, and that was LADWP's appropriative post-1914 water rights that were subject to the Water Board's jurisdiction under permitting and licensing authority. In addition, and I focus on that one water right holder, but that's not without saying that the magnitude of the City of Los Angeles and the Department of Water and Power's rights were not significant. I mean, obviously you had the economy of the City of Los Angeles allegedly in the balance based on whether or not it could continue to get water from the Mono Lake tributaries. But it helped focus the interest that you really only had that one single water right holder that was a party to the proceeding. All of these diversions were occurring in the headwaters. They weren't transiting down past untold other water right holders. You were not dealing with migratory fish. It really was, and there was a significant visual public trust value associated with the Mono Lake Basin. These are all things that lend themselves to focused decision making. And yet, what did you hear from Board Member Del Piero earlier today? You had 43 days of evidentiary hearing. We won't count the nights. You had 14 parties to the proceeding, most of which were public agencies, but only one of them was actually a water right holder. Metropolitan Water District also appeared as a party in the proceeding, but largely took no position on some of the key issues and certainly wasn't doing it as the appropriate water right holder that was the subject of the proceeding. You had more than 125 witnesses. And that was, again, just to assess the very straightforward, narrow issue. We keep calling it a public trust decision, but the very straightforward, narrow issue under Fish and Game Code 5937. Now, the question is, how well does something like this scale up to a larger basin? When you don't have one water right holder, where you're not dealing with a single family of dams to which 5937 can apply, but instead you're going back to Justice Broussard's National Audubon decision. And while it's loaded to some people, it is a all-encompassing consideration, balancing, some might say, of protecting the public trust where feasible and accommodating water rights consistent with those public trust values and doctrines. The complexity of a public trust decision does not grow in a linear function with the number of water rights in it. I say that when you look at those kinds of proceedings, it really is an exponential function. And if you put that through a traditional adjudicative lens, you really are looking at a recipe for inaction, dysfunction, and slowness. Now, one other aspect of our broader decisions that Justice Roby and Justice Blease at times have made clear through their decisions that we need to consider if we're going to be undertaking these adjudicative decisions is the priority scheme, the same scheme that you heard discussed by the prior panel. The issue of priority, when you are dealing with a single water diverter, as you were with the LADWP, becomes largely irrelevant. You are applying the public trust doctrine to that particular holder. However, at the same time, as we expand out across larger basins, such as the San Joaquin or the Sacramento River, there are relative priorities amongst all of those water right holders that further magnify and complicate that function. The complexity of the decision becomes more and more troubling. You have to consider how the public trust doctrine applies in the aggregate, but then also potentially to all the individual diverters. And instead of the diverters potentially being aligned with one another against a particular adjudicative decision that's advocated perhaps by the Department of Fish and Wildlife or by non-governmental organizations, you see the appropriators starting to play against each other, trying to articulate how waste and unreasonable use interfaces with the public trust doctrine and their relative priorities. It's all of these factors that lead me to conclude that you cannot do an effective single-purpose adjudication of the public trust doctrine on a grand scale. That said, the Water Board clearly has an obligation post-National Audubon to consider the public trust. So what are the other tools? The other tools that we can use in order to accommodate not only these issues, but municipal preference issues, as well as take advantage of some of the benefits of physical solution, which you heard described by Andy Sawyer in the prior presentation, as well as physical solution concepts that were put forward in Justice Blease's decision in CalTrout 1 and CalTrout 2 that would provide a framework in order to address the public trust needs without strictly adhering to traditional water right priorities. And this is also something Justice Roby has written about in the El Dorado Irrigation District case. So one of the things that as we increase the scale, is it allows us to look at different reaches, different segments of the watershed, and how perhaps migratory species move through those different segments and allow that to adjust our public trust balancing. But again, in the context of an adjudicative proceeding, that can be very difficult to address. So what's the other lens the board uses? It is the quasi-legislative process, the board process that was used to establish, for example, the Bay Delta Water Quality Control Plan. Now, again, going back to Law School 101, what are some of the hallmarks of a legislative proceeding? One, they don't have the accoutrements and strict rules of evidence. Two, they have a much lower barrier of entry because you don't need individuals who are as knowledgeable in the idiosyncrasies of the practice of law to get evidence in, to get witnesses examined. That no right of witness is something that, or pardon me, scratch that. Thinking about these legislative decisions, though, it lends itself to the type of questions that we're trying to answer here. Specifically, what are the broad needs across a large basin where you're affecting more than one person? That is truly the hallmark of a legislative decision by an administrative agency. It is the broad classes of individuals affected by that decision. And that is where, when you look at how to apply the public trust going forward into larger basins, you are naturally drawn to the idea of using a quasi-legislative process to lower the barrier of entry, allow a wider cross-section of stakeholders to contribute to the decision-making process before the board, and also it allows you to explore avenues of solution, whether it's a physical solution approach or otherwise, that may be more difficult to prove, quantify, and support in an adjudicative proceeding. But that quasi-legislative process comes at a cost, and that is the cost of potentially due process. Obviously, in the context of Mono Lake, Bear Creek, other decisions, there is a significant water right at play. And water rights are instrumental in the development of California and in the furtherance of its industry, agriculture, and its communities. And one of the things that has been most vocally contested within the water rights community is the ability to adjust those rights without going through a legislative, or adjust those rights without going through a full evidentiary adjudicative proceeding. Now, the courts have, as the panel before us discussed, recognized that there can be opportunities to adjust water rights through a quasi-legislative process. But I think the utility of those is somewhat limited unless the board approaches it in a fairly flexible manner. The two hallmark decisions that you heard Andy Sawyer, David Elajam, and Dan Fuchs and Nancy Murray discuss are the Light versus State Water Resources Control Board case involving frost protection regulations, and then, of course, the decision involving Caltrat 1 and 2, where Justice Blease essentially referred to 5937 as a legislative manifestation of the waste and unreasonable use doctrine, and then you've heard how that's been blurred over time to also refer to it as a legislative manifestation of the public trust doctrine. Now, in each of those, though, you don't have an absolute legislative edict. Instead, you have something that remains fairly flexible, such as what constitutes a good condition for fish below a dam, or in the context of the frost protection regulations, it was an instance of determining that the uncoordinated diversion of water for frost protection was a waste and unreasonable use. Neither of those are bright line tests that give you a determinative answer as to is the public trust being protected. And so I say that the quasi-legislative framework is only of value in protecting the public trust to the extent that it has built into it a flexible approach that allows the incorporation of the public trust doctrine to take account of varying circumstances throughout time. And to that extent, it leads me to where the Water Board will likely have to go as it approaches broader decisions. And there's a path that's somewhat already been laid, and that's in the Bay Delta, where you will continue to see initial broad legislative determinations put together through a basin planning process, a quasi-legislative process. It will provide the framework that can then follow on with a more detailed water rights decision that allocates that responsibility. The board is going to have to proceed in caution as it does this, mindful of the water rights, the significant water rights interests that are protected by constitutional due process. But it also provides an opportunity and a framework to ensure that some of the larger questions are addressed through a more open and transparent process, leaving the fine details of how water rights will be adjusted within a comprehensive and large basin to the specifics of the water right proceeding. There isn't a single miracle cure for this. The board is going to have to tackle this issue in light of National Audubon, but what it's going to require is a lot of creative minds, and it's going to require engagement by all of the stakeholders who are participating in the proceeding. Because as was pointed out earlier this morning by, I think, both board member Del Piero, but then also by Professor Dunning, the public trust doctrine is not a single-minded, unbending doctrine. It really does accommodate a wide range of interests. And so it really behooves both the water right holders who may potentially be subject to the public trust doctrine, as well as the non-governmental organizations and the Department of Fish and Wildlife, those who may be advocates for public trust resources, to fully engage in the process, because there is no certain outcome. And if they want to evaluate and pursue creative solutions, they really need to work within the framework that's established in the board's decisions. And with that, I'm going to hand it over to Richard for a more detailed conversation on the San Joaquin.
And as summarized for Richard, Michael queued it up very well, but Mono Lake case involved a single water right holder, so how do you go to scale on more complex systems? So, Richard?
Good afternoon, everyone, and thank you, Lester. I'm delighted to be one of two attorneys on a panel of 5. I will talk about the application of the public trust doctrine in the Delta watershed. And I'll begin with a lesson from the Mono Lake cases. A water right should accommodate or reconcile the bounty of our navigable waters and economic productivity. The bounty that you see behind me speaks for itself. As to economic productivity, let me paraphrase the California Supreme Court in its decision in 1983. The economy of the world's 8th largest economy depends upon the storage and diversion of waters up to hundreds of miles. Now here we have a photograph of A.V. Thomas in Atwater, California. This is the largest producer for organic sweet potatoes in the country and likely the world, and is just one of thousands of examples of the wisdom of what the Supreme Court said in 1983. Now, of course, there's an equation where bounty and productivity are different variables. And let me run the equation one way. Today, under Decision 1631, Los Angeles is receiving a water supply whose market value easily exceeds $10 million a year, with commercial and industrial activity a multiple of that. And yet, if you go to Lee Vining and stand on Main Street in front of the Mono Lake Committee, also the Chamber of Commerce, any day of the week, you will meet people from New York or Mississippi or China. People are coming from all over the world to see this bounty, and they're spending money, estimated to substantially exceed $10 million per year. So I begin with that lesson, and then I ask, how has the State Water Board implemented these cases since 1994? And by and large, the prior panelists have said all that needs saying. Let me just make one simple point. In the Delta watershed, there are tens of thousands of rights. By and large, the application to date, while significant, has not begun to deal with that scale. In my view, we have persistent conflicts between ecosystem protection, or the public trust, and water supply throughout California. I'll begin with the Delta watershed. And let me read Decision 990, decided in 1961. The board had just concluded that there is a persistent and emerging conflict between the Central Valley Project, the State Water Project, and Delta farmers, and salinity, which is one form of the public trust, or more precisely, water quality is. And the board said that it will reserve jurisdiction for a reasonable period not to exceed about 3 years, subject to extension, for the purpose of allowing the United States, the state of California, and the water users to work out these conflicts. Now, in 2009, the legislature declared the deltas in crisis, and I'll say no more. But let me take us to a different place to make this same point. Oops. Nope. The slideshow is omitting my next photo, which is a water wheel used specifically for the purpose of catching fish. In the Klamath Basin, as recently as 1920, there were multiple canneries at the mouth, and there was actually a device that looks exactly like a water wheel that scooped the fish out of the river in order to deliver them to the canneries. Imagine abundance of anadromous fish on that scale. Today, we've lost at least 95% of that abundance. So I see persistent conflicts between the public trust and water supply, notwithstanding the wisdom of the Supreme Court in its decision in '83 and the due diligence of the State Water Board in D-1631 and thereafter. And that worries me, and it should worry all of us, because of its persistence. But climate change will make these conflicts worse. And here we are, back to Mr. Vorster, standing on Stein's Stump in Tenaya Lake in January of 2012. Now, Peter didn't fully explain what this stump means, so let me do this. This stump is at least 30 feet tall. It's there because as recently as 1300 AD, this was a meadow, not a lake. And it was a meadow because a drought had continued for over 400 years. Our water supply system is based on the assumption that the worst probable drought is 7 years, and yet the record, even before we think about artificial climate change, shows that's optimistic. These persistent conflicts are causing significant economic disruption as well as ecosystem losses. And so I will offer 3 recommendations for change. 2 of them are designed to be provocative. I hope they are, in terms of your thinking and also good discussion. They all involve the State Water Board. In other words, they all involve enabling the State Water Board to better fulfill its statutory and even constitutional responsibility. And as I think about these recommendations, as you think about them, I ask you to put yourself ahead 20 years. So Berkeley Law holds a 40th anniversary of D-1631 in 2035. I want us to be able to answer 2 questions. As between the rights in the Delta watershed, who has the right to divert what and when? And as between these rights, who has the burden of protecting the public trust? In short, these questions are about real-time management, whether it's instantaneous or more likely monthly or seasonal. We need to be able to manage our water resources on a real-time basis, and we must answer these questions, in my view, in order to do so. Now, these recommendations involve all water rights, not just post-14, not just appropriative, also riparian. There, I'm drawing upon the wisdom of the Racanelli decision, where the court decided that all rights, not just the junior rights with specific reservations of authority in their permits, could be held responsible to contribute to water quality standards in the Delta. And I also draw upon an even older precedent. I'm taking us back to 1884. This is Gold Run Ditch in the American watershed. This company was founded in 1870. They bought the land at the top of the photograph, and they were using hydraulic mining to wash the soil and the rock down by more than 1,000 feet. You see them here roughly halfway down that face. And of course, in doing so, they caused catastrophic damage to navigation downstream. In 1884, the California Supreme Court heard a case brought by the Attorney General against this specific company, which was one of many, as well as unincorporated. I mean, gold miners were not a particularly ruly bunch, so no doubt many of them were unincorporated. The remedy ran against this company and all other miners performing this act and stopped it. The court did not distinguish between that defendant and the others. It said that act itself must stop or be changed in order to protect the public interest. So here's recommendation number one. The State Water Board should establish a digital database of all water rights. Now, this seems obvious. And yet, if you walk out this door and turn right and go across the glass, through the glass stairway, you'll get to the docket room. For the Mono Lake cases, less than 1% of the records created in those 43 days of hearing, and before that and after that, less than 1% is digitized. The licenses themselves, as well as the reports of use. But the hearing records, Hearing Officer Del Piero told us about 1,000 exhibits, and correspondence that is now flimsy yellow carbons dating back to 1932, none of that is digitized. And that's true, by and large, for other rights throughout the state. In order for us to manage water rights as a system, we must know what's there. And so I recommend that we establish a digital database that includes not just the licenses and the reports of use, but all documents, searchable by author, topic, and date. The Federal Energy Commission has done this with their hydropower licenses under the 1935 Federal Power Act, and we, after all, are California, which invented the very technology that FERC is using to digitize its records. We can do it. It will cost easily 5, possibly 10 million or more. And I will say, before going further, I believe that the dysfunction that I just described is a function of budget and budget only. But if we're serious about solving these persistent conflicts, we need to know what the rights are. So let's digitize the records, all of them. Second, the State Water Board should encourage regional settlements. Now let me begin with the precedent here. The Mono Lake cases are often thought of as a war between the Mono Lake Committee and Caltrout and DWP until that magical day when DWP didn't appeal. Well, the truth, as I think you now understand, is that DWP quite deliberately entered into what amounts to a settlement, not to appeal. It's not written. You can't find it anywhere. But they made a deliberate decision not to appeal, and that is, almost by definition, a settlement. And indeed, the parties did the same thing in 1998 to further define the restoration program, and have done the same thing yet again in 2013 to push that program even further. So the Mono Lake cases really shouldn't be thought of as just a litigation. They're much more interesting and subtle than that. In my opinion, the settlements, frankly, define those cases. I'm asking for more of this on a regional scale. Now, there are precedents, including the settlement contracts in the Sacramento Valley between senior water rights holders and reclamation, or the exchange contracts in the San Joaquin. But I'm talking about something that is bigger than a reconciliation of rights. I'm talking about settlements which square rights with the public trust and are then subject to regulatory approvals and governance to assure they're implemented properly. Now, there are promising developments in the San Joaquin and Sacramento basins in this respect, negotiations that are underway. I will say one thing about what the State Water Board can do, practically speaking, to encourage such settlements. And I'll draw upon a very different regulatory program, namely the Public Utilities Code, where in 2003, an administrative law judge was faced with PG&E's bankruptcy, and he had to deal both with the financial issues and the environmental issues associated with divesting 140,000 acres of watershed land. The judge called the parties before him and said, "You have 2 weeks to reach a settlement. If you do, I will approve it. If you don't, you will go through the worst trial, the worst nightmare any of you has ever experienced." 2 weeks later, plus a day, we came back with a settlement. So that's one thing the board could do to encourage such settlements. But let me move now to the last recommendation, which is again intended to be provocative. And that is, the State Water Board should use its statutory adjudication procedure in the absence of such settlements. Now, for attorneys in the water bar of this state, when you say statutory adjudication, I'm frankly reminded of the famous girl who was moving to the mining town of Bodie in 1870, and she said, "Goodbye, dear God, I'm going to Bodie." Attorneys, stakeholders, regulators all have the same response, which is we're looking at decades and decades of work. And I guess my question, paraphrasing Winston Churchill, goes like this: what's the alternative? Churchill was once asked about democracy, and he said, democracy is the worst known form of government except for all alternatives. So let me read to you from the Conservation Commission of 1912, whose report formed the basis of the 1914 Water Commission Act. "Of all the natural resources, there is none more valuable, more necessary to present and future generations of California than water. However, in California, water litigation has never settled the rights of any persons." Remember, I'm reading from 1912. "Never settled the rights of any persons other than those parties to each suit. If, therefore, there be 100 water right claimants on any stream, the rights of each of those claimants can never be fully settled until each claimant sues each other claimant and a final decision is rendered. If the water rights of this state are to be finally, expeditiously, and economically cleared up and determined, some agent of the state must be given the authority to go onto the streams, make the necessary investigations, and declare, subject to court revision, what water rights are." So let me say that several states, including Montana, Idaho, and Oregon, have recently completed adjudications which confirm the nightmare. For example, the Klamath adjudication took 37 years, and yet they did conclude. And they now have those decrees as the basis for real-time management of their waters. So what do I think this recommendation would mean for California? First, I think the budget would have to be $100 million. Again, drawing on the actual cost incurred in other states, likely $100 million. We'll need ALJs, administrative law judges, or special masters. With respect to the extraordinary dedication of individual board members, they simply cannot do this on the scale and on the schedule that's necessary for success. We need administrative law judges and special masters, a small army of them, and frankly, they all need to be grumpy. I once appeared before a Coast Guard administrative law judge at a pretrial conference with multiple parties, and he looked at us and he said, "There are multiple motions here. You're free to argue them. If you do, and you repeat a word you've already written, I will rule against you. Mr. Roos Collins, what's your preference?" I said, "Your Honor, I rest on the pleadings." grumpy, meaning driven to reach results. So what procedures might we use to avoid the problems which Michael rightly identified? Right holders must submit all documents. It must start with the right holder, not the board. Second, the division of water rights, or perhaps the special master, should have the capacity to investigate these submittals and make proposed findings of fact and conclusions of law. Litigation should proceed by exception to those proposed findings and conclusions. Where there are common issues, they should be resolved in common. Where there are issues unique to particular rights, they should be addressed in that manner. Let me conclude. Lester, you haven't given me the hook yet.
Well, I was just getting ready to, and then you said conclude. So
I sensed that my plea for additional time would be denied. So let me conclude by reading what I consider to be inspirational thought from Colonel Bob Marshall, who wrote in 1919 the plan that became the Central Valley Project and the State Water Project. He said, in its climate, its fertility, and its fitness for healthful human use, the land in the Valley of California cannot be found anywhere on earth. Success, as California measures success, is assured only when the enterprise is planned and carried out in its entirety. With the above assurances, it at once becomes a necessity, with now as the psychological moment. Now is when we need big work and big success to realize our future. So if you remember one thing from this talk, it is all hands on deck. Thank you.
thank you, Richard. Probably should remember the $100 million thing too, but Tim, broader water management and public trust. You're up.
I couldn't help but notice when I don't think you guys don't have the questions that the panelists got. Everybody has unique questions except for Martha and myself, who we're both asked to basically address technologies and strategies for water supply. That's extremely, I think, appropriate for reasons that I'll try and explain a little bit here. I did testify twice in the Mono Lake cases. The first was before a judge in North Lake Tahoe, not a terrible place to spend 3 or 4 days, most of the time twiddling your thumbs. The essence of that testimony was you can't solve this problem by raising price. I think much more important, I testified before the state board as one of the 40-some witnesses that they had. And the essence of my testimony was that we had to have a system that was flexible enough and resilient enough that when science said you need to solve an environmental problem in a particular place here in Mono Lake, we could adjust the resource portfolio and do that and maintain water supply reliability for the city of Los Angeles. It was a statement of what we now call co-equal goals, or an application of what we call co-equal goals. The thing that I found intriguing from the first time I met Martha Davis was that was exactly the argument that Martha was making, at least at a strategic and policy level. Martha never approached the city of Los Angeles without some sort of strategy for how they would maintain water supply reliability. It was absolutely central to the strategy that she had for protecting Mono Lake Committee. And frankly, privately, I saw some of the things, and by the way, she would help them pay for it. It struck me as interesting that it took so long to get to a deal when the basic deal-making formula seemed to make so much sense. Now, we differed on details. I was emphasizing things like functional delta. I was a big advocate in those days for water marketing and saw water marketing as a tool that would give us the kind of flexibility we're seeking. I'm sure I mentioned storage programs or alluded to them. I was negotiating groundwater storage agreements in Kern County on behalf of the Metropolitan Water District at the time, talking about how it was important to spend money to keep the Colorado River Aqueduct full, all of these being tools for flexibility that we didn't have 10 years prior to that, but we were investing in, and because of that flexibility, LA would survive if the Mono Lake got some water under a board decision. Now, Martha's testimony focused on recycling water, most of her counter strategies. So we had tactical differences at a level that I thought then, think now are resolvable, but on the strategy and policy questions, I was relating to the public trust doctrine as a doctrine that's very consistent with what we now call co-equal goals, and I think so was Martha Davis. In my organization, at the time, the Metropolitan Water District, prior to that, we didn't wait for the Mono Lake case to start changing strategies. And the way let me try and explain it the way I was a speaker with a bunch of realtors in Los Angeles last week. I'm going to run you through a little thought experiment I did with them. Imagine that you're a group of realtors, and that I'm explaining water supply situations to you in California in the 20th century. If it's 1910, I'm going to tell you how important it is to build the Los Angeles Aqueduct to meet the needs of a growing economy. If it's 1930, I'm going to tell you how important it is to meet the needs of a growing economy by building the Colorado River Aqueduct. If it's 1960, it's a state water project. Every 30 years or so, there would be a new project to import water from far distances. I went to work at the Metropolitan Water District in 1985, and by the time we got very far into my career there, we weren't giving that speech anymore. A man named Carl Baranke, not because he loved the environment so much or anything else, he was a practical man. His job was water supply reliability for a big economy, and he knew that completing the state water project, which was to be the next big import project, wasn't going to do the job. So Carl surrounded himself with a capable staff and looked at alternatives. And if you think about it today, this is remarkable. We don't get credit for this very much, and it was triggered by things like the Mono Lake decision. That 20th century cycle of new imported water supply was broken at the end of the 20th century, and in the 21st century, the Southern California Plan for Water Supply Reliability is virtually totally focused on developing local resources to meet the needs of that growing economy. That's a remarkable shift. Again, I don't think we recognize it. We don't get credit for it, but it was started by people like Martha in the things that she was doing with the Mono Lake Committee. And I tell the story of the past when I'm supposed to talk about the future, because sometimes if you're on the right track, stay on it. I think we are on the right track. We need to accelerate those investments and do more of that sort of infrastructure and technology to reconcile the differences between the environment and the economy in the future. But the challenge before us now is we have to go beyond just local and regional investments. We have got a statewide system that was built back in the middle of the last century, and it is not consistent with co-equal goals. So we've got to resolve these infrastructure technical differences amongst us as the intake for the projects in the right place. I don't know how anybody could rationally argue that it is. Do we have enough storage in the system to manage for co-equal goals? I don't see how anybody, frankly, could argue that we are. But take the other side. Let's have the argument. Let's work our way through it. So. Again, I told a little story of the past because I think we are on the right path and we need to stay on it. We need to accelerate that path. I think the state board can help us do that. The groundwater law we just passed, you watch that one. It's a game changer, which will focus a lot of investment, I think, in the right place. So, as always, I'm an optimist, and I think we're going to work our way through it. I'm hopeful that another thing that happened in 1994, I don't know if it's been mentioned before today, was the Bay Delta Court. I was one of the negotiators for the Bay Delta Court. 20 years ago, I think it's fair to say that all the combating stakeholders, the urbans, the ags, the environmentalists, we actually were taking seriously the objectives of the other parties. We were trying to fashion something that looked at those. That lasted less than a decade. It was the victim of the pelagic organism decline and the Wanger decision. And then we've been roughly a decade into gotcha. But if you look at the passage of the Groundwater Act, if you look at the passage of the bond, any major action that's got both NRDC and the Westlands Water District as a supporter, maybe something powerful is going on. I'm thinking there is the basis to build that kind of partnership that we had 20 years ago, and not that we'll agree with each other on everything, but that people have some incentive to try and resolve those agreements in ways that work for all the parties sitting around the table.
Great. Thank you, Tim. Matt, obviously in public trust, a lot of reference to fixing the fisheries, so that presumes we know something about it. So fill us in on ecosystem restoration issues in public trust.
Thanks, Lester. And it's quite extraordinary to be here to have both Mark Del Piero and Lester Snow pronounce fluvial geomorphologist correctly. So thank you. I am coming at this from more the science perspective, and I'm reminded that as a graduate student I worked up in the Mono Basin, and then later during the hearings gave some testimony This is me measuring flow in Rush Creek back in the 1980s. Great place to work, fascinating place, and as has been alluded to, a lot simpler than some of the problems that we've been dealing with since. Okay. So, trying to look beyond the Mono Basin to applications elsewhere and some of the scientific and fishery issues. One, we do have to recognize irreversible changes to the ecosystem. If you look at a lot of the classic literature on stream restoration, there are allusions to going back to pre-disturbance conditions or functions. And that's hard or impossible to do in many cases. It doesn't mean we can't do something useful. But we have to recognize constraints. If we're working downstream of a dam, the flows have been altered, the sediment load, the barriers to passage. And to what extent do we simply accept those constraints, the changes as constraints, and to what extent do we look at those changes and try to reverse them or modify some of those, the flow or sediment or passage issues? I think when I first started in working in restoration 25 years ago, when I would talk to engineers, the assumption would immediately be whatever the constraints are, you accept them. Oh, there's a house on the floodplain. Well, we can't have any flow on the floodplain. The flows of the high flows have been reduced. Well, therefore, we have to live with that. We're seeing, obviously, more willingness to examine these changes and decide, are they irreversible or not? On our working rivers, we are seeing an attempt to downscale the natural processes. So obviously, most of the water is going somewhere else, but we still have some of the water to play with. Can we use that to create an artificial flood that will mobilize gravels, that will flush out the fine sediment, that will scour some of the willows so they don't invade the channel? Can we still have an active channel? It won't be as wide as it was before, but is that still possible? And then I think it's also important for us to recognize this incendiary mix of salmon and the Mediterranean climate, as I'll try to expand on. And then finally, are there ways that we can more strategically allocate our restoration resources? And can we use a triage approach sometimes to be more effective? So first, a principle is the most effective thing actually is if you have a river that's working, preserve it. Keep it with the natural processes going. The next most effective thing is to try to restore or let the river restore itself. And we can do that where if we look at this diagram, on the y-axis, it's stream power and sediment supply. On the x-axis, it's the degree to which the channel is encroached by urbanization. So if you are in the upper right, you have room, you don't have a lot of encroachment, and you have stream power and sediment supply, the river is capable of rebuilding its channel. It could have been straightened, but if you leave it alone, take the levees back, get rid of riprap, within a few floods, it will probably be well on its way to a natural form. However, we often don't have that situation. Often we're in the middle, where flow and sediment have been altered, say below a dam. In these cases, we have to look at each one of those alterations and see to what extent can we recreate some of the natural process. Because that is by far the most effective way to restore the habitats and the species that depend on them. And this is important to recognize our context, that we are in a Mediterranean climate. And as typical of Mediterranean climates, highly variable seasonally and year to year in terms of water availability. And the water is available out of phase with demand. Lots of water in the winter when we don't need it. We need it in the summer, so we have large storage projects. And there, of course, are gradients in where the water exists and where we need it, elevational and altitudinal. So we have big canals that move the water to the farms. And this is not unique to California at all. This is exactly the same thing you see in Spain, Portugal, southern France, Chile, all the Mediterranean climates have very similar systems. One thing about Mediterranean climates is we have a much higher impoundment ratio. So the percent of the runoff in a given river that is impounded by dams is much larger in the Mediterranean than elsewhere. These examples, 60% for the Ebro River in Spain, 80% for the Sacramento, 120% for the San Joaquin, compared to 20% for the Potomac, 5% for the Elbe. And if we look at what is the effect of all this storage, we have effectively taken the energy out of the rivers. So this is a map showing the reduction in the 2-year flood, which is often taken as a geomorphically effective flow on the rivers of the Central Valley, going from a 94% reduction on Puda Creek, which is a very large dam on a very small river, to 33% on below Shasta, 88% below Friant. We can look at this in another way. This is the mean monthly flows, and this is the way Puda Creek has been altered. Well, what you can see here is there's the same amount of water under the curve, it's just been redistributed. The flood flows have been chopped off, stored, and then it's released in this bizarrely bloated base flow in the summertime. And that then, of course, is sucked off by the irrigation. And if we look at a very different system, but also with big changes, the San Joaquin. Puda Creek was a winter rainfall runoff system. San Joaquin is a snowmelt system. And here we see those big snowmelt peaks in the summer months completely eliminated. We don't see them redistributed anywhere in the hydrograph. Where do they go? Into the Friant-Kern Canal, the Madera Canal. These are massive canals, 5,000 CFS capacity for Friant-Kern. These are big rivers that are rediverting the San Joaquin to very productive agricultural lands. Now, what I've talked about so far, these are not unusual for Mediterranean climates. It's the same thing you'll see on the Ebro, other parts of the world with Mediterranean climates, but what you are not going to find anywhere else are the salmon. The salmon complicate things for us. They evolved in this environment thanks to the cold snowmelt, groundwater, and they can find thermal refugia. They are very adaptive. A lot of phenotypic plasticity, meaning that they actually evolve to accommodate these higher temperatures and conditions. And it's really only here that we have this kind of species with this kind of prominence, a charismatic metafauna protected by legislation, many of the runs, and this creates a lot of clashes between water rights, ESA, and other kinds of regulations. Now, one thing about our situation in the Central Valley, while the dams have cut off most of the habitat, at least for the spring run, we're fortunate that there is no big dam downstream blocking the main stem system-wide. Many rivers have this. They have a big dam below that cuts off the opportunity to do anything upstream in terms of migration of organisms. Fortunately, in the Central Valley, the dams are in parallel, not in series. One thing this means is that we could decide that the Tuolumne River has the greatest restoration potential, and we could throw all our restoration funds at the Tuolumne, let the Merced go away, let the Stanislaus, don't worry about those. This could be a much more effective way to achieve real results in restoration. Politically, how easy is this to do? This is triage. It's a topic that came up when I was on the CalFed Ecosystem Restoration Science Board. We wrestled with this question. We asked this question. We weren't really encouraged to proceed with it, but we did ask the question. And as a first step, we thought, at least if you are funding all these little projects all over the landscape, at least there should be some kind of analysis to project, at the end of 20 years of funding all these little things, what is that likely to have achieved for us? An example that we used, and this is a paper that we published raising this question, was filling gravel pits on the Merced or Tuolumne River. And there's something like 15 gravel pits, big projects, quite expensive to fill a number of them. The question was, if you fill half of the gravel pits, have you reduced the predation of juvenile salmon by 50%? Probably not, but it depends on your assumptions. But this kind of question hasn't been asked, really, or at least been properly addressed. Two cautionary tales. The first one, the San Joaquin settlement in 2006, 12 years after the Mono Lake decision. The agreement to restore flows to restore the spring run Chinook that had gone extinct because of Friant Dam. We developed restoration hydrographs for 5-year types, and these were accepted in the settlement agreement. This is an example for what we call the normal wet year. And these were designed to provide sufficient flows to mobilize gravels, move juveniles downstream, and so on. So this is an example of trying to downsize a river. Is it working? Well, after actually more than a decade, flow regime is still not implemented. No spring run Chinook have been introduced into the river as intended. Why not? Well, there is a certain aversion to risk-taking, which tends to preclude adaptive management. And there are constraints imposed by the inadequate levee system, problems of seepage onto ag lands if you put water down the channel. And so far, the only action attempted, a bypass around Sac Dam, was stopped because of subsidence induced by groundwater pumping.